So talking about Section 39 of the Constitution, which is your interpretation section. This is an instruction to all courts and tribunals. Okay, so what it says is, when interpreting a right of the Bill of Rights, a court, tribunal, or forum must, remember must in terms of interpretation of statutes, must promote the values that underlie an open and democratic society based on human dignity, equality, and freedom. Must consider international law and may consider foreign law. Remember, the distinction between international law and foreign law is international law is comprised of treaties, agreements, jus cogens, and peremptory norms, as well as opinio juris, international law. Foreign law is law from a different country. So, for example, what does it say? How does something work in Botswana or the UK or so on? Section 39.2 says, when interpreting any legislation and when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and objective of the Bill of Rights. The other important thing is that the Bill of Rights does not deny the existence of any other rights or freedoms that are recognized or conferred by common law, customary law, or legislation to the extent that they are consistent with the Bill of Rights. That is to say that there aren't only rights found in the Bill of Rights. There are other rights. So again, I talk about Esther a lot, but Esther confers the right to family life. We see the right to family life in international law as well. We don't see it directly worded in the Constitution, but nonetheless it exists. So with that interpretation in mind, we now need to ask ourselves, okay, for the example of rights-based litigation, we find that there is a piece of legislation that we feel is inconsistent with the Constitution. Can it be interpreted in a way that lines itself up with the Constitution? This is called the generous. I'll get into interpretation style soon, but this is the generous form of interpretation. Can we think of the offending legislation in a particular way that gives effect to the Constitution? If not, if it is so obvious, then we go to the limitations question. If not, we'll go, if we don't think that the limitation is justifiable, we continue. But the limitation section is very important. The limitation section we find in section 36 of the Constitution. So what section 36 says is that, in fact, certain rights can be limited. Not all rights are absolute. And in fact, it would be very difficult to operate in a world where all rights are absolute. Freedom of expression being absolute, freedom and then dignity being absolute, they're inconsistent. I might need to make fair comment about somebody in public power, but it's not going to look very good for them. And so they can say dignity was infringed, and I can say freedom of expression was infringed. And so we need to draw a distinction and find our balancing act. So section 36 says that rights may only be limited in terms of application to the extent that the limitation is reasonable and justifiable. Again, going back to our founding principles, in an open and democratic society based on human dignity, equality, and freedom, taking into account all relevant factors. This is telling you what a court will do when considering whether or not an infringement of a right is justifiable. They take into account the nature of the right. There's, of course, a table of non-derogable rights. You'll find that in the Constitution as well. Your non-derogable rights are equality, human dignity, life, freedom and security of person, slavery and servitude, obviously not the right to slavery, but the right not to be a slave, the rights of children, and the rights of arrested, detained, and accused persons. These are non-derogable rights. So, the nature of the right, can it be derogated from, or can it not be derogated from? Can it be limited? Then we look at the importance and the purpose of the limitation. I think the clearest limitation that we can all draw from is the national state of disaster. We had our freedom of movement infringed. Our right to work infringed. Some might argue a lot more rights have been infringed. All our rights were limited, not necessarily infringed, because if we take into account the nature of the importance of the right and the importance of the limitation, we might see that it was reasonable and justifiable in an open and democratic society for the state to take drastic public health steps that limited our rights in order to keep everyone safe. Then we look at the nature and the extent of the limitation. Let's look at the limitation on cigarettes, for example. This was found to be an unjustifiable limitation. It's still pending appeal, I will grant you, but the minister overstepped the bounds by limiting our right to smoke. They said that it was because of public health that smokers would put an undue burden on hospitals at the time that COVID was going to put an undue burden on hospitals. But in fact, the only thing that was infringed was our right to buy cigarettes, and not necessarily the right to smoke was not unlawful. That limitation was found to be unreasonable because it didn't have a direct correlation between the purpose of the limitation and the nature of the limitation, i.e. it was found scientifically that smokers did not place an undue burden on the healthcare system. You compare and contrast that with the alcohol ban, where the alcohol ban did have a real scientific basis for the prohibition, because alcohol does lead to more pressure in hospitals, and the hospitals were overburdened. That ban was found to be justifiable because the nature of the limitation had a reasonable test to the nature of the limitation. It did fix a problem, in other words. Then we look at the relationship between the limitation and its purpose, which is what I've just been talking about. And then we ask whether or not, or rather the court would ask itself, and we would provide information to that effect, whether or not there are less restrictive means to achieve the same purpose. So that also tells you that any limitation of rights must be must be a law of general application, but the state must employ the least restrictive means to limit a right. When you're doing your inquiry about whether or not a limitation of a right is justifiable, your first question is it a law of general application? If it's not a law of general application, then the limitation is unjustifiable at the outset. Okay, so your argument would be that the limitation is unjustifiable in terms of Section 36. Then we move on to our next step, which is our remedies stage. So remedies we can find both in Section 38 and Section 172 of the Constitution. So we look at our remedies in terms of Section 38, which is called enforcement of rights. Anyone listed in this section has the right to approach a competent court, alleging that a right has been infringed, right? So this is whether, in terms of remedies, Section 38 says whether or not you're bringing this in your own interest, your rights, or your client's interest, your client's personal rights have been infringed, or are you bringing this on behalf of a group of persons, an association of persons? Are you bringing it in the public interest, or are you bringing it on behalf of a class? Remember, I said classes are really, really tricky creatures, because first you need to certify the class, and the court, there's a whole range of tests, and I would implore you to read the silicosis judgment on this. The court has a test that it must apply in determining whether or not a class exists, and that the class is sufficiently similar in order to proceed. Classes are difficult, and that is why they are rare. Then we go to Section 172 of the Constitution and also look at the remedies that are contained there. And I'm just flipping to my Constitution as I talk to you, so give me 2 seconds. Okay. 172 is the inherent powers of the court. So when deciding on constitutional matters within its power, remember that means we're not talking about the magistrate's court or the small claims court, a court must declare that it must, go back to interpretation of statutes, must means must. It doesn't mean could, it doesn't mean discretion. Must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. And then the court may make an order that is just and equitable. They may make an order limiting the retrospective effect of the declaration of invalidity. This is because retrospective application of law leads to terrible uncertainty and would in itself be unconstitutional in many circumstances. Then the court may also make an order suspending the declaration of invalidity for a period in order for, say, Parliament to remedy the infringement. A clear-cut example of this would be the gay marriages case, where a couple brought to the Constitutional Court the fact that they could not marry because they were a same-sex couple, because the Marriages Act only recognized marriage as between one man and one woman. Then, the Customary Marriages Act recognized a whole host of other kinds of marriages between one man and many women. But same-sex partners could not marry. So the Constitutional Court declared the Marriages Act to be invalid to the extent, not the whole thing, just to the extent that it did not allow for same-sex couples to marry. That declaration was suspended for 24 months for Parliament to come up with a solution. Remember, they give this declaration of invalidity and then give Parliament the opportunity to fix it because of the principle of separation of powers and that they don't want to step on somebody else's competency. In that case, after the Constitutional Court had made the declaration of invalidity, there was a massive outcry from religious organizations saying that if the state expanded the definition of marriage, that would be an infringement of the sanctity, not a right, but the sanctity of certain religions. The state capitulated and created the Civil Union Act, which gives all the same rights as marriages would, but they don't call it a marriage. I'm fairly sure that your mind is going towards the concept of separate but equal at this point. Separate but equal doesn't work. Separate but equal is gross. However, our state has decided that separate but equal is the right way to go. I find it to be difficult, separate but equal, in terms of the story of same-sex marriages. But I don't draft law, and I've yet to have a case where somebody says they would rather be married as opposed to in a civil union. So yeah, you need to look at your remedies and bear in mind that you might not get an instant relief. Matters where you're going to get the declaration of invalidity being suspended, that's generally going to take quite some time, so caution your clients. Also something that you generally bring in the public interest and not in the interest of an individual member, although the marriages case was brought by an individual. Okay. Section 172 goes on to say that the Supreme Court of Appeal, the High Court, or any court with similar status as the High Court may make an order concerning the constitutional validity of an Act of Parliament, Provincial Act, or any conduct of the President. But an order of constitutional invalidity has no force or effect unless it's confirmed by the Constitutional Court. So remember, if you are bringing an application for declaration of invalidity on a section of legislation or on the conduct of the President, then you know that you're going to go first to the High Court, get your declaration, and then you're going straight to the Constitutional Court for confirmation proceedings. Blind SA, I think I mentioned that in a previous clip, but Blind SA is going to the Constitutional Court for a confirmation hearing on the declaration of invalidity on certain sections of the Copyright Act, and that'll be early next year. So keep an eye on that because it's going to be fun and interesting. Please also bear in mind that the section that I've just mentioned, section 176(2)(a), does not state that the Magistrates Court or the Small Claims Court or any other court that's lower than a High Court can make any finding. But of course, the specialized courts have a similar status to a High Court. Okay, so a court which makes an order, this is going on to section 172(2)(b), a court which makes an order of constitutional invalidity may grant a temporary interdict or other temporary relief that may adjourn the proceedings pending a decision of the Constitutional Court. This is going to be heavily dependent on the nature of the complaint and the nature of the relief sought. Okay, so then national legislation must provide for the referral of an order to the order of constitutional invalidity to the Constitutional Court. Just saying that the national government can't block the referral of confirmation to the Constitutional Court, and any person or organ of state with sufficient interest may appeal or apply directly to the Constitutional Court to confirm or vary an order of constitutional invalidity. So we see that anybody can get involved at a later stage. So, moving on to, where am I? Moving on to the question of direct application in terms of Section 8 of the Constitution.